Thank you so much for joining us for this webinar on trauma-informed lawyering. We're just waiting for everybody to come in from the waiting room and then we'll begin. So it may just be silent for one moment. Thank you.
Thank you for joining us. My name is Shushan Liu. I'm the Deputy Lead for the Children's Rights Group at Doughty Street Chambers. I'm delighted to welcome you to today's event. We're going to launch a guide on trauma-informed lawyering in the youth justice system. This guide is part of an ongoing partnership between the Youth Justice Law Centre at Just for Kids Law and the Children's Rights Group at Doughty Street Chambers. And you'll hear in due course from Shawneen Lamb and Aswini Ratna QC, who have huge expertise on this topic. Another colleague of ours, Leonie Hurst, also contributed to the guide and will be joining later. And the Children's Rights Group brings together barristers from all practice teams in the chambers working on issues relating to children's rights. This is the 5th in the series of guides, all of which can be found on the websites of Doughty Street Chambers and the Youth Justice Law Centre. I have no role here today other than to welcome you to this launch. I have the enormous pleasure to introduce you to today's chair, Shawneen Lamb, who co-authored the guide. I doubt Shawneen needs much introduction. She is the Director of Impact Law for Social Justice and is the co-founder and former CEO of Just for Kids Law, where she set up the Youth Justice Legal Centre in 2014 and now serves on its advisory board. A barrister in the UK and a practicing attorney in the US, Shawneen is a true legal innovator dedicated to the law being a tool for social change. Without further ado, I will hand over to Shawneen, who is chairing this launch. Thank you very much.
Thanks so much, Shushin, and thanks everyone for joining. We're really excited about this webinar. It's another great collaboration between the Children's Rights Group at Doughty Street Chambers and the Youth Justice Legal Centre at Just for Kids Law on the new legal guide, Trauma-Informed Lawyering in the Youth Justice System. As with all of the guides, this production has been a collaborative effort, gathering the leading experts with knowledge of what it means to be trauma-informed in the law to converge into one guide for you, the practitioners in the youth justice system. Some of those you will hear from this afternoon, and others without whose contribution the quality of this guide would be much poorer, include, as you've heard, Leonie Hurst, barrister at Doughty Street Chambers, Dr. Zoe Given-Wilson at the University of Holloway Centre of Emotion and the Law, who has developed trauma-informed expertise in the context of asylum-seeking children. Bob Schwartz, former executive director of the Juvenile Law Center in the US, who's very kindly shared with us all of the American resources and his insights. And before we start, as always, I want to thank Katia Moran and Laura Cooper, who head up YJLC, and Ruth Heyman, who has taken over Katia's maternity leave, Laura's maternity leave. Sorry, Katia, just giving you another baby. Laura's maternity leave. Laura had her baby boy 2 days ago. Thank you so much for all of your work in making sure the guides are accurate and look beautiful and that they are disseminated to the broadest audience. The guide provides an overview of what trauma-informed lawyering in the youth justice system is and why it matters. But this is a relatively new area, we think, within the youth justice system, especially amongst lawyers, maybe not so much amongst yacht practitioners. We really feel that all lawyers working with children need to be aware of trauma and its effects. And that's why we've got experts who have also worked in other jurisdictions where perhaps this is more developed, not just the youth justice system. And we hope the legal guide gives practical tips on how to work in a trauma-informed way, and when and how, if needed, to introduce evidence of trauma to support legal strategies. And Sinead Marriott from Great Ormond Street will discuss later how expert evidence can be presented. So without further ado, I'm going to hand over to Melissa Rutherford first. Melissa is a director at Rutherford Sheridan Solicitors and a criminal advocacy tutor in Strathclyde University. She specialises in criminal defence and immigration. She has experience of family law and also children's hearing systems in Scotland. She's an advocate of being trauma aware, and I think leads the kind of trauma informed work along with another solicitor in Scotland. She's a co-founder of Trauma Aware Lawyers. She's a trustee of Join the Dots organisation and Indigo Childcare charity. So Melissa, I will hand over to you.
Thank you so much, and thank you for inviting me to speak to everyone today. It's an absolute pleasure. I have no pressure going first with all of these wonderful speakers, so hopefully you'll find it interesting. I'm not sure how much information that the practitioners know about trauma, but essentially in Scotland we have led, I guess, a movement of lawyers, and particularly of educating people within the legal system about trauma. So trauma will impact your clients, and the behaviours that they will show are as a result of the traumatic experiences that they have faced. So we all have experience of difficult clients, perhaps clients that are very hard to like. However, if you look beyond that and you have knowledge of trauma and show practices that are trauma aware and trauma responsive, you will be able to break down that barrier, recognise the behaviours, and hopefully build a good, trusting and long-standing relationship with them. For people that don't have a background in trauma, I guess it would be helpful perhaps just to state that following a medical study of doctors in the United States, there were stressful events in childhood that were identified that impacted people's behaviour as they grew up. And these can include often a lot of the lives that our clients have had, such as domestic violence in the home, addiction in the home, neglect, physical, sexual or emotional abuse, or growing up with a parent in prison. Further studies and further experience, I guess other topics such as bereavement, bullying, growing up in poverty, suffering homelessness in childhood, and growing up in a community that has violence would also impact a child and how they would progress. If they don't have, for example, an adult that they have a good buffering relationship with, these stresses that have occurred in their childhood can impact the development of their brain, which I'm sure Sinead will be able to speak more in depth about, and it can lead them to be in a flight or fight mode a lot of the time, which means that they can't process information properly. The behaviour that they then experience leads them to addictions, to violent behaviours, and basically leads them right into the criminal justice system, where we then meet our clients. So as a result of what has happened to them, they may then do bad things. I guess what we have been advocating in Scotland is look beyond the crime. The person isn't a bad person. They may have had a bad thing happen to them, and they may then have done something bad, something criminal, but they're not a bad person. A lot of studies have taken place with this adversity that's occurred in childhood, And quite shockingly, for someone that has 4 or more of these stressful events happen to them, they are 15 times more likely to have committed violence against another person in the last 12 months. The stats go on, and the increase for drug usage and for ending up in prison. So someone with 4 or more stressful experiences 20 times more likely to have been incarcerated at some point in their lives. When you go to the prison population, 8 out of 10 of the prisoners have suffered 4 or more adverse childhood experiences. And if you move down to the likes of the youth incarceration places and Pullman and things like that, we call them in Scotland. There'll be various organisations throughout England. When you move to them, it's the Young Offenders Institutes. 9 out of 10 of the offenders have had 4 or more of these stresses in their early lives. So I think it's vitally important that as practitioners in this area, that you have a deeper understanding of trauma, how to react to people, how to understand and empathise with them, and also then how to advocate for them in court. I, along with Ian Smith and 2 other solicitors, started a group called Trauma Aware Lawyers in Scotland, and this was as a result of us working independently throughout the court system, trying to raise awareness of trauma and the impact of trauma in the criminal justice system, particularly, although it does extend beyond to the whole of the legal system. Any legal argument, any legal case that you work with a person can be impacted by trauma. So we started the Trauma Aware Lawyers group at the very end of 2020, and to date we have spoken to all of the law schools in Scotland about trauma. We contacted them hoping for them to reply, and every single one of them replied and asked us to speak to their students, both in the LLB and the postgraduate diploma in legal practice, which is the qualification you require to practice as a lawyer. We have spoken to all of the law schools in Scotland in the last 3 months. We have also engaged in really meaningful discussions with the Law Society of Scotland, with a view to incorporating a course on trauma within the LLB or the diploma, and at least 3 of the law school providers have agreed to do this, which is absolutely amazing. I can't believe the progress that has been made, but it just shows that there is clearly an appetite for ensuring that the up and coming lawyers of the future are trauma aware, and that they can empathise with the clients that they deal with. The response we've had from the students has been spectacular. There's been huge engagement directly on social media. They've contacted us through email, and all of them have been really, really appreciative that they've had the opportunity to learn about this at the early stage. We had moved forward to the top level, and we'd spoken to the Judicial Institute, who are responsible for providing education and training for sheriffs and judges. They have been keen, but not overly keen to actually have full engagement in a training programme, but they do appreciate and understand the relevance. So we're still working hard with them. The positive in Scotland is that the Scottish Sentencing Council are in the process of preparing sentencing guidelines for young people, and as a result of the research and information, they have extended the treatment of a young person to the age of 25, and they've moved that up to reflect about how the brain develops, and that at the age of 25, some may argue actually beyond that, it's only fully formed at the age of 25 or after. And these guidelines, although they're in draft, we can still refer to them in court, although they're not binding, and we're hoping that they will be published soon. These really the appeal court, along with the Sentencing Council, are really keen to ensure that children are treated differently, and young people up to the age of 25 are treated differently from adult offenders. They want judges and sheriffs and decision makers to make sure that the sentences that they are providing are they're taking into consideration the possibility of rehabilitation, the lack of maturity, and understanding of a young person. And also they have specifically said the experience of trauma. They've not really gone into a huge amount of details, but they have referenced that a sheriff or a judge has to consider a young person's experience of trauma when sentencing them, which is absolutely amazing. That really is where we want to be, having trauma-informed approaches to sentencing. So we have hopefully engaged a lot of the professionals, but there's still so much more work to be done. With the Scottish Government, they have indicated just earlier this month about the Bairns House, which is a Scottish version of the Barnhouse Scandinavian model, to have a child-centred approach to child witnesses in the criminal justice system, and also the Promise Plan, which is a 10-year plan for engagement with all parties: education, health, social work, law, anyone that deals with care experienced children and families, to give them a better outcome for trying to keep families that have experienced trauma together as far as possible, where it's safe for the child, and to allow families to remain together to try and relieve any further stressors. So it's hopeful that we can engage, the lawyers can engage with this in the future, and Scotland will become hopefully trauma responsive and not just trauma aware. I have some resources I normally share to the law schools, and I would be happy to share them with anyone. I can speak to the group about this if anyone wants it, and I'm happy to connect and answer any questions at the end of this. Thank you very much for listening, and I hope you enjoy the rest of the speakers. I think I'm passing back to Shauneen now.
Thank you. Thank you so much, Melissa. I'm now very honoured to welcome Dr. Sinead Marriott to join us. Sinead is a psychologist based at Great Ormond Street Hospital and an independent expert who provides psychological reports in the criminal justice system. Many of the cases that you will have read about, Sinead has been the expert witness in those cases. But her areas of expertise are looked after and adopted children, post-traumatic stress disorder, complex trauma, conduct disorder, and neuron elopement. She also works with children with attachment difficulties. In her day job, she provides individual treatment for children at Great Ormond Street, EMDR and trauma-focused CBT, as well as behavioural interventions. Sinead has published on assessment and treatment of post-traumatic stress disorder in children and the assessment and treatment of complex trauma in children affected by domestic homicide and psychotherapy with young offenders. So I'm sure you'll agree she's very capable of speaking on the subject and will be extremely helpful to the legal practitioner. Thank you so much, Sinead.
Thanks so much, Shauneen. Thank you. Can I have the next slide, please? Right, thank you. Thanks. So just to start with, what I thought would be helpful to think in what we're talking about in terms of psychiatric diagnosis. So trauma is what people are exposed to, and then what we're interested in is whether people have, whether people develop PTSD. So it's helpful for you as lawyers to know what we're talking about when we talk about PTSD, and these are the criteria that people would have to meet that, to receive that diagnosis. So it means that you have to witness or experience a stressful event with a perceived risk of serious harm, and the perceived bit is really crucial with children, because actually something might not really necessarily be a risk of serious harm, but in a child's mind it's very traumatizing, because they, their kind of cognitive level means that they perceive it as something really, really dangerous. And we're interested in whether people are re-experiencing the trauma. So that means that they're constantly kind of flooded with thoughts about what happened, or really strong emotions, or they have the same physical sensations that they had at the time of the actual incident. So it's very distressing. So they'll have all the physical symptoms of the kind of heart beating really fast, or they might have some smells associated with the trauma. So that's really what we're talking about when we talk about flashbacks. It's really somebody feeling as if they're back in that actual situation and they're kind of reliving it all of time. And the symptoms include avoidance, so that might mean that they want to avoid talking about what happened. They want to avoid any people or places that remind them of it. Negative thoughts and feelings. So if somebody's got PTSD, if they've been very traumatized, it changes the way they view themselves. So people will have negative core beliefs that include feeling that they're not safe, that they're worthless, that they are to blame for things. They feel very guilty, and these things kind of affect their whole sort of outlook on life, and how they expect other people to act towards them. And then you have increased arousal. So as Melissa was saying, you know, trauma has a massive impact on our development. So it changes the way our biological systems are reacting to quite innocuous events. So we can feel very, people will be very hypervigilant, which means they're in that constant fight or flight state, constantly waiting for when the next kind of traumatic event is going to come. So, and they will also be very irritable. They won't be able to pay attention or concentrate, and they won't be able to sleep. So you can see how all of those things together are going to increase somebody's risk of offending, and have an impact on their engagement in all of the things we would want them to engage in to reduce the risk of offending. Next slide, please. Thank you. So as well as PTSD, we talk about complex trauma, and in the kind of new diagnostic manual, whenever, we're not sure when that's coming out, but perhaps the next year or so, there is now going to be a formal diagnostic category for that. So complex PTSD or complex trauma means when people have been exposed to the sort of things Melissa was talking about in their early life. So where you have multiple traumas happening over and over again. So that might be sexual harm, domestic violence, parents with addiction issues who are behaving in very unpredictable ways. So, and the difficulty with complex trauma is not just that you're exposed to more trauma, but also you've got less protective factors, because the people causing the trauma, or the people who aren't protecting you from the trauma, are your primary caregivers. So it's not that you're somebody who's got this nice, safe home life and then you go out and some traumatic things happen. It's that you have no respite from trauma. And also it's because complex trauma happens during the kind of crucial developmental stages. And as Melissa was saying, you know, this affects how our hormones work. It has, you know, massive impact on our physical and mental health and our behaviour. So you would see disturbance across three kind of key areas. So how well people are able to regulate their emotions. So how well they can kind of communicate and recognise anxiety or anger or sadness at an early stage and take steps to reduce it. So they're much more likely to not feel anything and then to suddenly be, often people are described as 0 to 60, so they're fine and then they're kicking off. Negative self-concept, as I've said already, feeling really worthless as a person, really feeling to blame for everything, unlovable and unsafe, and disturbances in relationships. So not expecting adults to be able to protect them, and so not being able to take kind of instruction or engage with people, accept help, or engage positively with authority, which again, we see with a lot of our young people. The next slide, please. Thank you. So all of these kind of symptoms can make people present in very different ways, really. And when I did this list, it kind of doesn't really discriminate, because basically, if they present as guarded and not talking about things, or flat and lacking in emotion, or very irritable, or very sad, however they're presenting, it could still be trauma. So you would always be trying to really look for what's gone on in their lives. So if they're irritable, it makes it much harder to engage with them, and you're obviously trying to, you know, find out the information you need to make a form of defense. So you're trying to talk to them about something very stressful, and you'll often feel like you're treading on eggshells with people who are traumatized. Bravado is another kind of presentation that I've noticed, where they'll be very denying of any vulnerability, or that anything that's happened to them has had any impact on them, and they won't really want you to instruct a psychologist or to you know, put in a defense that makes them look vulnerable in any way. Also, they'll kind of you know, unhelpfully make out they're more involved in offending or gangs than they actually are. obviously quite avoidant, reluctant to engage. Disorganized is another key issue. If they're not sleeping, then they're not going to turn up for early appointments. So certainly, I know that just for kids, if they're arranging for me to come in, we try and be quite, you know, I wouldn't book a 9 o'clock appointment to see any of these young people. And then how the presentation also increases their risk of offending is that often if you're dealing with all of that sort of re-experiencing and that being overwhelmed by very difficult emotions, you're going to be much more likely to be using drugs or alcohol to kind of numb those feelings. You're much more likely to be isolated, not engaging, not going to school, and therefore much more at risk of being groomed. And another issue that I've noticed a lot is that often the fact that they're traumatized works against them because it can make them come across as having aggravating factors. So actually they can end up with a higher sentence because they're not able to show remorse, and they can come across as very desensitized to violence, and they don't show their vulnerability. So all of those things kind of count against them unless we can sort of demonstrate to the court a kind of rationale for that and help it make sense to them. The next slide, please. Actually, I'll skip past this slide because I think Melissa talked really clearly about that. So for trauma-informed practice, sort of from my experience, what I think, I'm always amazed by how much information the lawyers who instruct me have before I have to see them. So I always feel like they're kind of half working as, you know, they've done half the psychologist's job. But lots of detailed questions, not just have you been traumatized, it has to be specific about have you seen an adult hit another adult in your family, you know, really going into that level of detail, because they won't see it as traumatizing, they will see it as their normal life. That's just normal life to them. And explain why you're asking that question and that you're not going to ask lots and lots of follow-up questions. You know, basically you just want to know roughly if some of those things have happened, and then you can unpick, and how it's affected them, you can unpick it later. And it doesn't always have to be, you know, the instructions to the expert needs to be quite general, not just have they or haven't they got PTSD, because that reduces it to something quite dichotomous that can then lead to just a disagreement of opinion between experts. But really, what events in their background have had an impact on the decisions and actions in events surrounding the allegations, and always include asking experts to give you recommendations otherwise about how to treat the trauma and the PTSD, because otherwise all you're doing is making them look much more risky and perhaps making the judge think that they would need to be locked up because of all these terrible things that have happened to them. So next slide, please. So I'll just very quickly I put 2 case examples in, but as we're short on time, I'll just quickly do this one. So Clara was 17 when I saw her, and she was on remand for murder and robbery. She'd had an absolutely shocking history, which I've just detailed there. And her solicitor had really done a really good job of engaging her and getting her to talk to me, because she didn't see any of these things as shocking. And the fact that she was traumatized was so crucial to the events surrounding the alleged offences, because she had literally come from a relationship with a man in his 30s, and she was 16 when she'd had a very violent incident with him, and she'd left him. And she made a conscious decision. She said she just decided, I need to go and get very, very drunk. The people she decided to go and get very, very drunk with then kind of wanted a favour from her and wanted her to get a guy to come to a certain location, which she did without questioning. And unfortunately, that man was murdered by that group. So she was in a very, very, very difficult situation. But I think with the report from myself and just how well she'd engaged and all the information she'd given us, and the youth offending team did a really helpful report as well, and conclusive grounds NRM referral, the court were able to give her she was found not guilty of murder and got a community sentence for the robbery. So that was example of where it's helped have a useful outcome for a young person. Thank you so much. I thought I should probably leave that one because we're out of time. Thank you.
Thank you so much, Sinead, and I'm sure people will want to, we'll be able to share the slides at the end and provide the bibliography that was there in at the end of Sinead's slides. So thank you so much for that. I am now is an honour to pass over to Professor Felicity Gerry QC. She is an international QC at Libertas Chambers in London and Crockett Chambers in Melbourne. Felicity has a particular interest in homicide law, including murder and manslaughter, especially multi-defendant cases, applying the law on complicity. And she was the leading counsel in Jogi, which corrected an error of law on joint enterprise. She also advises in relation to death penalty matters in Indonesia and Philippines and citizens held in the Syrian camps in cases involving torture. Felicity has over 25 years experience of cases involving allegations of sexual offending and is co-author of the Sexual Offences Handbook. So I'm sure this is where all of her experience and knowledge of being a trauma-informed lawyer comes from, and she has been involved in writing and developing advocacy toolkits for questioning vulnerable witnesses and vulnerable defendants. Felicity is also a professor of legal practice at Deakin University in Melbourne, and most recently she's written a two-part series entitled Trauma-Informed Court, on why being trauma-informed is an issue for court integrity. So you can see why she is a great expert for us to have at this webinar. Thank you, Felicity.
Thank you, Shawneen. I hope you can all see and hear me. Not to talk too much about myself because Shawneen has introduced that, but the horses example you see on our first slide really comes from before my career, that I learned to talk to children because I had to teach them to ride horses. And if you can't communicate simply and clearly, then they might get hurt. So I brought to the bar my experience of communication with children, upon which I was never trained. And in my fourth year at the bar, I was given a case involving sexual offending against very small children. And again, there was really no training on what to do. So I'm delighted at this legal practice guide that helps lawyers to understand what trauma-informed means. I have a graduate certificate in university teaching and learning, and you learn very quickly that when you're even teaching law, that there's a percentage of people in the room who are living with trauma that has caused me to do research in Australia, particularly on communication with Indigenous people who suffer generational trauma. So there's a lot of learning to be done, and I think this work by the Youth Justice Legal Centre is really important so that we can be specialists in cases involving vulnerable defendants in all sorts of areas. Next slide, please. So this slide, I'm not going to read it all to you. Those of you who want the slides can ask for them afterwards. I know they'd be provided, but we can start to think about stress or emotional distress. How do we define trauma? There's a lot of disagreement at times about how we define trauma, but it can be absolutely overwhelming and it can be triggered by an appearance in court. And as lawyers, we really need to understand that can happen. And this particular definition in 2002 was adopted in the toolkit that is available in Australia, where Carnes argues that this definition is culturally sensitive and covers the full range of potential impacts of traumatic experiences. So as lawyers, we need to understand that trauma is an event or process which is overwhelming, and it can overwhelm the individual, family, community, and in particular the ability for someone to cope. And understanding that is really important before you ever get to the doors of the court, and should inform the whole of our practice. Next slide, please. At the end of that last slide, without switching back, of course, I think it I totally agree with the last speaker that we really need to understand that challenging and oppositional behaviour is not necessarily criminal behaviour or bad character. It's actually as a result of traumatic experiences, and often people living with various conditions, including complex post-traumatic stress disorder. So my research, and I think I'm really here with my Deakin University and Advocates Gateway hat on, is to look at court centres as places where trauma is ever present and how we can tackle it for a range of court users. And the conclusion that I came to from this research is that trauma is really an issue, not just for lawyers, for which this publication by the Youth Justice Legal Centre is fabulous, but it's really an issue for court integrity. But because if we don't trust our courts and our legal systems, if our courts and legal systems don't respect the dignity of people who are living with trauma, then what the research tends to demonstrate is that there's a real lack of trust, that the courts don't understand the people within it. And it requires practical adaptations, but also fundamentally changing the way we do things. And we can start to think easily about areas such as police interviews, how traumatic that must be for an individual, particularly a child. The idea that we draw adverse inferences against particularly children in court seems a shocking development in law to me, to hold it against someone that they might keep quiet in such a traumatic situation. The procedural adaptations that we've made are good. There are a lot of special arrangements for witnesses, can be quite different for defendants. There's a real difference between the criminal courts and some professional disciplinary systems where the same issues are heard and yet much more comfortable environment. So court buildings is an issue. And obviously moving trauma into a question of substantive law as to where that might be useful in cases involving complicity, where understanding someone's trauma might help understand their behaviour on a particular day and say, well, they're actually not part of a joint criminal enterprise. I find really interesting. But cantering through slides onto the next one, because I know I've given you quite a few. I think the core of what I want to say is this on this slide, that the integrity of a criminal justice system is linked to its trustworthiness and its fairness. And if people are living with trauma and that is not understood in the criminal justice system, then it isn't trustworthy and it simply isn't fair. And it has a real impact on the legitimacy of the courts. And what I really like is the research project for the judiciary of Trinidad and Tobago. And they were effectively, I suppose, accused of lacking integrity, whether it was formal or not. But what they did was open themselves up to research. And they looked at fair process, equality and respect, integrity being essential. This was not a trauma-informed process, but what the courts did was open themselves up on how can we actually be procedurally fair? What does it actually mean to be fair? And it's such a unique insight into court systems and the judiciary that it's freely available online, and you'll get the resources at the end of the slide. But I think it's such a unique insight that it's worthy of rolling it out and seeing how fair our court systems really are. Next slide, please. So what does procedural fairness mean? Well, this research referred back to some work in 2008 that said, well, what does procedural fairness actually mean? So we've got some definitions. As lawyers, we like a definition. So voice, neutrality, respectful treatment, trustworthy authorities. It's not the language that we tend to use in the criminal courts in England and Wales in particular. So we could debate for a very long time whether the adversarial system is effective, but I think there's a bigger question to have around trust and confidence in the administration of justice if we are running trials where persons who are living with complex traumatic experiences are not having those experiences recognised. They're therefore unlikely to be participating to their full extent, find it difficult to express themselves, are subject to biased decisions where you have prosecutors who want to rely on small pieces of information that are not explained and can only be explained by reference to those past experiences that then put the person on the back foot in relation to explaining that particular day. So some real lack of balance in how we treat people who have past experiences that may include past conduct. So I think this is a real question for how our authorities are trustworthy. We know so much now as a result of the research that we've just heard, as well as this research on court systems, that it really is beholden on us to, as lawyers, to say, well, look, we understand trauma. We've got the legal practice guide. We're really thinking this through. And this has to result in systemic change. Next slide, please. So what the research showed, and again, I'm going to summarize this slide, is that when you actually ask people, as they did in Trinidad and Tobago, what they said is, well, actually, the process is more important than the outcome. We understand that people are going to be found guilty or not guilty. There are going to be outcomes. But what's more important is the accountability, the availability of amenities, access to information that the court is seeing as being inclusive and understanding. And I think that's really important. Public opinion is often said to be about punishment, but actually when people are asked, what they want is their court systems to be trustworthy and that due process matters more than the result. And if the result goes against an individual, they can see the legitimacy. This research showed that they can see the legitimacy in the result if the process has been inclusive. And I think that idea of fair process really matters. Thank you. Next slide, please. So what we have to do is adopt trauma-informed evidence-based approaches. That involves understanding somebody's particular situation. That can be true of every stakeholder. So witnesses, complainants, defendants, lawyers, judges, court staff, everybody coping with a range of adversities that require not just practical adaptations, which the American Bar Association is well ahead of us, and as is the guidance in Australia, but forcing the adoption of those trauma-informed practices in court, which is a huge hurdle in England and Wales. Next slide, please. So the core takeaway that I have is trauma-informed systems within institutions enable this voice opportunity, this perception and experience of inclusion, transparency and fairness, and all of that can increase trust and confidence in court authority, which in my view is significantly waning. We've had decades of discussions around vulnerability and adaptations for vulnerability that doesn't encompass all court users. And the use of stakeholder and court user may not be the language of the criminal courts, but it does need to come to the point where trauma is recognised, and recognise that it will also come with some challenging behaviour. And a trauma-informed lens to criminal justice policy can, of course, in turn tackle the negative impact on the participation in those processes. It can have tangible effects. The research says so. There's plenty of it. This guide adds to that. Next slide, please. And you can look at the research that's in the slides that I've provided, that if once we understand that it's a range of experiences that can contribute to trauma, then the effect it can have is on coherence, consistency, credibility, and is then used to undermine someone's reliability improperly, in my view. Actually, totally irrelevant to people's answers quite often, but not understood. Next slide, please. So what we do if we're not trauma-informed is we fail to acknowledge or address those challenges. And that, I think, is what we are failing to do and where this guide contributes. Most of what's on this slide is in the articles, my 2 articles in the New Law Journal, so I'm not going to add to that. We can probably canter through the last few, but if we can go to the next one. I think this is where I step forward from the guide that we're looking at today. Trauma-informed lawyering, fantastic, totally important. We have a window into these issues. We're already trying to do what we can, particularly for clients. But I think this is an all of court approach. I actually think this should be driven by the courts and trauma-informed processes come from that core issue that I've identified, is the integrity of the court. I think I'm running out of time now, so I'll just finish off looking at the next slide. Yes, so what I think I've already covered this, that it's about accountability, that trauma has to be part of that accountability in terms of procedural fairness, so that we have a fully trauma-driven response. Next slide. That is achieving service-wide delivery. I love that language. It's just to get up the noses of all those people who don't want to learn about being trauma-informed. Let's have some service-wide delivery. There's some practical steps. Keep going, I can canter through them. And my conclusion is that trauma-driven response. Thank you very much. There's some resources on the last two slides that I'm sure you can be given. Thank you.
Thank you so much, Felicity, and I totally agree with you about the whole system being trauma-informed, which is hopefully what Scotland is a bit ahead of us at doing. The aim of the guide is, I suppose, specifically for youth justice practitioners to think of arguments of ways it can be raised in that specific context. But I think we could all as practitioners be aware of being how to be more trauma-informed in general, which leads right on very well to the next speaker, Sweeney Wararatna QC from Doughty Street Chambers, who very kindly inputted into this guide. And the reason why I think that's probably so important is because Sweeney is not a criminal practitioner, but is probably very aware of being a trauma-informed lawyer and what that means in other contexts. So Sweeney's expertise focuses on the protection of the most vulnerable, including children, usually because of mental disability or abuse or exploitation. And those of us who are criminal practitioners will know that that also applies a lot to the defendants that we represent. So Sweeney does litigation and advisory work with an emphasis on human rights, and works in a wide range of practice areas of public and private law issues, welfare and medical treatment cases in the Court of Protection, actions against state bodies for assault and unlawful detention claims, non-recent child abuse claims, inquests and inquiries, reporting restrictions and international law. Sweeney also has extensive experience of investigatory procedures, which are presumably less adversarial than the criminal courts that we, those of us who practice there, see, and in public inquiries. She's been an independent chair of inquiries, tribunals and professional regulatory bodies. She has chaired 6 independent homicide inquiries. She appears in courts and tribunals at all levels, including the Supreme Court. Sweeney, we're so grateful for your input. Thank you.
Well, thank you. I have to say, I am really honoured to be invited to speak today, and it's been fascinating but daunting to listen to experts and academics on this important topic, which really centres around youth justice system. And I, of course, as Shawnee has just said, come to this from the perspective of a civil practitioner, where I'm going to say, obviously, trauma-informed lawyering is no less important, but where I would say, and I hope I'm not being too unfair, that it is less well developed. And I bear in mind what Felicity has just said about the criminal system in that relation too. And I'm talking about procedurally and substantively. So most of what I do, I do and I know has been learned on the job. I work with dedicated solicitors and who are also learning as they go along. And so, to be honest, this is the first time I'm really pulling together what I know. And bear with me as I feel that my thoughts are a little rough around the edges, and I think this has been a big task. I'm going to just touch on some headlines that provide a flavour, I think, of what I know. But put succinctly, I think the hallmarks of trauma-informed lawyering are putting the realities of a client's trauma experiences at the forefront of engaging with them and adjusting practice to take account of those experiences. So as I reflect on my practice, it's been quite a long time, nearly 30 years now, I think it's correct to say that, as you've heard, many, if not most of my clients either have experienced trauma as children and are bringing civil claims for compensation as adults, or under specialist jurisdictions such as the Mental Health Act or the Mental Capacity Act. And the systems they interact with are the civil courts, tribunals, and inquiries. They will all inevitably be experiencing a range of mental health problems as a result of physical, emotional, sexual abuse, exploitation, which are either caused or exacerbated by systems of healthcare and welfare, or at the hands of individuals, and also through natural processes where there are issues of treatment and care and welfare, and possibly restrictions on freedom, private life, and often detention as well, a wide range. So my first headline point is this: whichever way you encounter clients in vulnerable situations, it's clear that there is, I think, a common approach as to how to support them. And I see this from the guide that's being published. An adversarial civil litigation process, or even an inquiry actually, as with the criminal justice system, is fraught with pitfalls and difficulties for traumatized clients. The quote in the introduction to this guide is so apt. It says, if one set out intentionally to design a system for provoking symptoms of traumatic stress disorder, it might look very much like a court of law. So the second headline is that litigation is an anxiety-provoking process for anyone and should therefore be avoided at all costs. While adjustments can be made within a courtroom, the steps leading to that courtroom need careful thought and handling. Even avoiding a trial in a court and settling a claim brings risks for a traumatized litigant. It still involves talking to lawyers and experts and making decisions about, for example, settlement offers. And I've faced a number of situations, and I have one ongoing at the moment where my client is an extremely damaged young person because of neglect in the family home, poor responses by statutory agencies, so that even when in care, they were subject to sexual assaults and exploitation, leading to severe mental health problems. This client has been assessed to lack mental capacity to conduct the litigation, and so the official solicitor has stepped in to give instructions. But even so, lawyers need to interact with the client and explain what's going on and what the decisions being made are. We have a decent offer of settlement, nothing close to the loss that was calculated carefully on the basis of a lot of expert evidence. The settlement was probably achieved partly as a result of that careful calculation, and also, however, knowledge on all sides that no amount of reasonable adjustments was going to enable this claimant to face giving evidence at a trial. And that's the civil claim double-edged sword. And that's my third headline. Maximizing compensation is particularly complex in this context, not just because clients find it hard to cope with telling their stories in the courtroom, but also because substantive issues of causation, for example, are often truly impossible to unravel, creating massive litigation risks. And the adversarial process means that a client's account is questioned and tested, and the potential for re-traumatization is massive. So my fourth headline is that alternatives to litigation, such as mediation, should always be considered. And they do provide a good possibility of a much more bespoke set of arrangements to deal with some or all of the issues in the claim and the needs of the claimant. So returning to trauma-informed lawyering, in my experience, I think there are four distinct stages or situations. So there's the personal interaction with the client, there's crafting a case, there's the court process, and there's also preventing vicarious trauma. And I've already said, I think there is a commonality across civil and criminal litigation. So I'm just going to pick a few points to highlight in relation to those aspects. So personal interaction is about identifying possible trauma and avoiding re-traumatization, in my view. For example, you may not know at the outset what your client is about to reveal to you. It's not unusual that survivors of sexual abuse, for example, request a female lawyer, which might give you a clue. But it's good practice, therefore, to have a preconsidered plan for such events. So all clients should be offered a choice of lawyer. And meeting a lawyer or any person in authority is often very difficult. Clients may inevitably be slow or reluctant to reveal the full extent of what they've experienced. So we've heard from Sinead that avoidance and shame are all features of PTSD, and that lawyers must be aware of that. And this is where building a trusting relationship, being reliable, open, clear in your communications, and always making sure there's good support, including during and after meetings. There's also, I think it's also very important to bear in mind that the focus of the advice sought may be quite different to the actual problem that emerges. A client may be experiencing social problems that first bring them into your office. They may be facing criminal proceedings, and a solicitor needs to be prepared to multitask and to seek assistance from other colleagues or agencies as appropriate. So I'm not going to move swiftly on before I get buzzed for my timing to the second point, which is about crafting a case and litigation strategy. So the strategy inevitably is to settle the claim before trial and as early as possible to avoid further trauma or re-traumatization. And this is probably one key difference with the criminal trial process. Inevitably, cases or civil cases rely on what's in documentary evidence, but also on expert evidence on liability and causation of harm. So a few words about causation and the proper use of experts, I think, might be useful. You will all know that untangling recoverable causes of harm is a knotty issue which relies on expert evidence. And good trauma-informed lawyering in this area includes the proper instruction of experts to unpick the evidence and to build your case. And in this regard, a point I think worth highlighting is that records, whether medical or social care, are often replete with characterizations of children into stereotypes based on unconscious biases. So this may be, for example, entries that characterize a child as difficult when they are newly taken into care. This might be through truanting from school, petty crime, challenging behavior, absconding, or placing themselves at risk of abuse and exploitation. It would be clearly wrong today for this to go unchallenged. Any of these attributes taken singly or more likely together, in my experience, I hope Sinead would agree, could be symptoms of a history of abuse and neglect. And it is our task to be alive to this and to make sure that the expert is asked to consider their etiology carefully. I was going to talk about criminal behavior and conduct, and also a history of drug and alcohol abuse, because these are all very important and are normally seen as detracting from credibility as a witness, and also have the potential to affect causation of issues such as employment and educational losses. And in my view, I think lawyers need to be open-minded as to the impact of trauma on the structure of a claim and losses being claimed, so that we do not allow these factors to negatively impact on the way the claim is structured. I mean, we already use expert assistance to analyze the impact of psychological damage on, say, employment, but we have yet to explore fully, in my view, the impact of criminality linked to abuse on employment losses. It's not an easy argument to pursue, but that doesn't mean it shouldn't be tried. I think I'm being told I've run out of time, but I'm just going to say something quickly about court process. One point, there are no ground rules for hearings in civil courts, as I believe there are in criminal courts, but there is sufficient flexibility through case management processes, and the Equal Treatment Bench Book does guide judges to be alert to the need for special arrangements. So I think that brings me to that point that Felicity made also. It's really an all-court situation that we need to be aware of and promulgate as lawyers. I'm going to stop there. I think I really run out of time. Thank you very much.
Thank you so much, Aswini. And it's been brilliant to hear this from everybody's different perspective. But now is the time for questions from the audience. And there are hundreds of you and loads of questions that I can see coming up. So if the speakers could turn their cameras on so we can answer the questions, and I'll try and get through as many of these as we can in the time remaining. First question, can I ask Sinead, could you explain a little bit more what ACEs are, including what the acronym stands for people who might not be so familiar with it, and what impact they have on children and young people, and also if in your experience courts and court staff are familiar with the concept of ACEs?
Yeah, of course. So ACEs stands for Adverse Childhood Experiences. So there's a checklist, a very simple checklist. So in the bibliography, there's a couple of references in there for some of the research on ACEs. And it's the things that Melissa and I were listing. It would be things like divorce, a parent in prison, parent drug and alcohol use, experiencing violence, sexual abuse, all those kind of things. And yeah, so the impact of those is, as Melissa was saying, that they've got really clear evidence that it affects every kind of possible outcome, and physical health problems as well. So your physical health is really affected by these things. But I think the most striking ones for our population was really how high the rates of incarceration are. So if you've got 4 or more ACEs, the study that was just done on an England population by the University of Liverpool, it was you're 11 times more likely to be incarcerated if you've got 4 or more of these, and 11 times more likely to be violent. I think Melissa was quoting another study which was even higher. I don't know if the courts and police are informed about this. It's definitely, it's been around since the 80s, so it's been quite slow to sort of take off. But it's, I think Scotland are ahead of the game, and America are ahead of the game as well. So I think I think it's something that should be filtered through, because it's so easy to use. So we're trying to get everybody at GOSH, all the psychologists at GOSH in the paediatric settings as well, to ask about trauma, because once you pick it up, you can start to offer people access to some intervention.
Brilliant, thank you so much. This second question, I think Melissa and Felicity and perhaps Sweeney can come in as well. How do you think all of the players in the court system, so obviously the guide is just directed at lawyers, how do you think that court system would act if everyone was more trauma informed? Melissa, do you want to start?
I think that's the absolute dream. That's where we want to be. Everyone that's involved in the court process, not just the criminal justice process, but the court process, has to be trauma informed and trauma responsive, and then we will have done what we need to do. And that goes from the court staff that takes your name when you walk in the door at reception, that tells you to take a seat or puts you somewhere quiet if you're looking vulnerable. And that's the bar officer. I don't know if there's different names in England for some of these roles. Obviously the sheriff, the prosecutor, the defence, everyone that deals with anyone in the court setting, and then the criminal justice social work, and anyone that deals with people. If they're all trauma informed and trauma responsive, everyone's going to be put at ease. Really the hope is that the jails will be empty and the courts will be empty, apart from a couple of drink drivers and your fraud cases. That's the future, hopefully, but I think we're many hundreds of years away from that. But yeah, if we all do our bit and everyone learns about trauma, I think it can make the whole court system less stressful, less traumatic. So I think a lot of people, certainly clients and people that have been involved in other cases that are victims or witnesses, have said that often the court process is more traumatizing than the actual event itself, which is it's pretty sad because we contribute to that.
Thank you. Felicity, your new articles are on trauma-informed courts. How do you think we can do this, and have you seen it being done well in practice? Is Felicity there?
Felicity, you're on mute.
Sorry, I haven't changed my button. So I think we've had a lot of conversations about vulnerability, and it's about changing mindsets, because people think, oh, I know that, I've been on a course, and they don't actually adapt the way they do things at all. And there can be some very minor practical changes that can be made, can just be about court listing or the signs in court or the welcoming atmosphere in court and changing the building, and some practical steps, of course, in my article. But there could be some more fundamental changes relating to witness preparation, lawyer care, myths and stereotypes for judicial directions on trauma, the effect of trauma. I think that's a really interesting area, because at the moment what you might have is the idea of someone's previous convictions being bad character, or actually it arises from their condition and we have challenging and oppositional behaviour. And changing mindsets on something like that is an enormous change, where those of us who lawyer with vulnerable clients know that sometimes the behaviour has been as a result of not being understood because they're undiagnosed, and they might be an abused child who's been failed by authorities, who has undiagnosed conditions, and their previous conduct is used as bad character to suggest they have a propensity to commit a crime. Now, to change the way we do that is an enormous change, but it comes from being trauma-informed and understanding complex post-traumatic stress disorder. Now, that's not to say that that inevitably means everybody's not guilty of a crime they're accused of, but it does enable us to put in context their behaviour and then to decide whether or not it's actually helpful to start looking back at what they've done in the past. So there are small changes that we can make. I think the worry that I have at the moment, that certainly in relation to those of us who work in the system, if we have our own stresses, being trauma-informed understands staff stresses as well, or lawyers' stresses, and that is currently an issue for well-being at the bar or by the Law Society, and I think that's really problematic as well, because you're placing the burden again on the lawyers for their own well-being and their professional well-being, whereas actually often the reason that we have stresses is because the court plays the game in the same way as it's played it for a very long time. So some big and small changes, some practical, some more fundamental, but otherwise courts are untrustworthy.
Yeah. Sweeney, as you've said, your kind of a lot of your goal is to not get people into court, and in the criminal justice system it's harder to do that. But have you seen in systems where they are more trauma-informed, maybe less adversarial processes, that could be practical tips?
Yes, I think you've picked up on the key issues there. I mean, institutionally, obviously, one can make changes, and those are very, very important. A lot of my cases are settle, and that's my success. I try and avoid the courtroom, but as I said, there's that double-edged sword, which means that you have to make those trade-offs, don't you? In any case, really, but specifically in these types of cases. I think in the courtroom area, when you've got a child litigant, it might be more easier, I'm going to say, to make the changes that are necessary to make that to inform the court's processes. But where you've got, say, an adult survivor of childhood abuse, and then you're in an adversarial process, the whole issue before the court is, was this person abused or not? And what is the level of trauma that they're suffering as a result, or is there any? And there's a dispute as to that. So that becomes a little bit more difficult in that adversarial process for a vulnerable adult litigant. And then to get a judge to, you'd have to have a specific hearing to get the judge to accept that certain changes were necessary. Clearly, it's much easier in a investigatory sort of process and an inquiry situation, and I've had that. I was part of the independent inquiry into child sexual abuse for various different participants, and certainly one, in fact, Felicity, I represented the Child Migrants Trust for the children who were migrated to Australia in the 40s, and they were some of them are in their 60s, 70s now, but massively traumatized people. And very sensitive processes put in around their participation with psychologists and counsellors available, in fact, for all participants in that setting. So I think a very informed, trauma-informed setting, but nevertheless still traumatic. I mean, there's a limit, I suppose, to how much you can eradicate in that setting, but much better.
Sorry. Oh, glad it's not just me.
I was doing that probably. Yeah. We can all do it. The next question I was going to ask was to both Sweeney and Felicity, was around those sex abuse cases where have you got suggestions for practitioners, for criminal practitioners particularly, of how ways you can keep a sex abuse victim away from their abuser once a case gets into the criminal justice system? Felicity, do you want to start?
Well, yeah, I think first of all, we have to recognise that where there's a dispute in relation to whether an offence has been committed, if that can't be resolved, and what we're really talking about here is having as many processes as possible not to go to court. And that I agree with, not prosecuting vulnerable people or finding a solution to ensure that a person who is a victim of a crime such as abuse doesn't have to give evidence about it. And there are a lot of ways in which that could be achieved, but sometimes we get to court and we have to have a process. So we need to recognise that we're asking people to talk about probably the most traumatic thing that's happened to them, on top of all those supplementary traumatic experiences that come from having had those major experiences, and to understand the complexity that that can cause and huge personality changes, to include mental health issues and other issues. So that's the environment that we're working in. There are models, obviously, as Sweeney's already told us, that if you have an inquiry, you might have a model that actually does that an awful lot better. And I mentioned earlier on disciplinary tribunals. So I've done cases involving sexual offending once in the criminal court and then again in the medical professional tribunal service, where it's relating to a sexual assault by a doctor or an allegation by a doctor. And the environment is so different. And I had a witness in one where she said, well, how would you feel if that happened to you? And of course, I'm asking her questions. And I said, look, I just can't sit down with you and have a cup of tea. And in front of the judges, that was fine. But in a criminal court, it's unheard of. But for me to say, look, I just can't sit down with you and have a cup of tea. I've got to ask you these questions. Are you okay? Shall we carry on? And it was just a much more careful, kind system where I had to challenge a witness that I'd had to challenge in previous cases in almost a different way. I tried to be as kind as I could. So I think, again, as ever, it's the lawyer's answer, it depends, but some of the things are minor adjustments that we have to make ourselves, but I think there are some major, major adjustments to the system, the people working within the system, the attitudes, all of those matters that we've discussed. So hopefully we can keep people away from the system, but that there are circumstances where, when we've got to be there, that it really needs to alter itself.
Thank you so much, Felicity. Sweeney, how about, I know you don't practice in the criminal justice system, but I'm sure you've heard people experiences of within the criminal justice system. Have you heard of better practice than the kind of stereotypical adversarial trial?
In civil litigation, actually not really. I think that, you know, as much as one tries to object to the style of questioning, say, or cross-examination and raising issues of trauma, particularly if there's a report that says someone has a PTSD, you will say, you know, please be aware that's we've got an opinion. So let's, you know, not cross-examine so heavily. We're not in a criminal court. But at the end of the day, claimant has to prove their case. And so they have to be subject to scrutiny over what they're saying as well. So there's a very difficult balance to be struck there. I have had a situation where abusers have been brought to court by an organization to give evidence on behalf of the defendant. And that, I mean, that can be dealt with, and probably in the same way as in the criminal system. You know, you can make arrangements for claimants not to encounter. You set the timetable, you set the procedure, so that sort of thing can be dealt with. But it needs forethought and it needs awareness, definitely.
Thank you so much. The next question, I hope you can answer this, Sinead. It's really for people who act as appropriate adults at the police station. Do you have any tips of how to provide evidence of trauma pre-charge, so to the police at the police station, and ways to minimize the trauma that children might feel, as you can imagine, being held at the police station?
Yeah, I mean, I think it's very difficult because it is traumatic. I think with all the roles of appropriate adults, it's really about making sure that they're going to be kind of proactive and feel able to challenge things and speak up at the time rather than just comment on it afterwards. I think just preparing children for what they're going to be asked and how much they're going to answer, and just how much leeway there is for not being able to give all of that information straight away. But if, I think similarly to, as I was saying, for the lawyers, just letting children know, look, I'm going to ask you, I need to get some of your background. I'm not going to ask you lots of follow-ups. I just want to make sure that people know a little bit about you and that you're treated fairly. So, have any of these things happen to you? Because it's very rudimentary, isn't it? It's so kind of it's not nuanced what people have to be able to do to be considered fit to be interviewed. So and I think just asking for lots of breaks and being able to speak to them separately and help them regain their composure, but also just, I think just that thing of not presuming that someone who's traumatized is going to present as very anxious and very tearful, making sure that people are looking out for kids who are just coming across as quite aggressive or irritable or just shut down and very unfriendly. I think those kind of things should be big warning signs. It's not then these kind of children with trauma are not the people who are internalizing their difficulties. They're much more externalizing it. So being very, I think, they're pushing away, so they're quite hard to help. So appropriate adults probably feel like they should back off, but helping, I think, if they can feel more able to be proactive and try and draw the person out, I think those kind of things would be helpful. And I think and sometimes it might be useful for experts to look at the police interview transcript or listen to it afterwards, because I've certainly seen some I've heard some sort of shocking examples of where the police, not maliciously, but through a lack of awareness, have just come out with the most awful things. So, for example, talking about how traumatized they've found reading about the offence, telling the child that, and those kind of things then can get addressed later on in court, because there is because that then had an impact on what that child, for that particular example, that child then went on and made a kind of false confession, really, because they were so sort of traumatized by the police's frankly quite bizarre sort of approach to interviewing a child. So yeah, I mean, but ultimately, I love hearing about how everybody's saying about trauma, really changing the whole system, and that's what it has to be. You can't just have the lawyers holding it up on their own and just, if you're just that single voice in the court, it just falls a bit kind of flat. And I think sometimes the other thing that I've seen in court is that the judges will be quite kind to the defendant. They will be able to get that they should be like that. But then if they're speaking to the defense barrister in a bullying way, or if they're speaking to the expert witness in a bullying way, the kids they're very astute and they pick up and think, he doesn't really mean it. I actually still can't trust this system. So it's how everybody speaks to each other that's important, and ultimately adversarial system is quite traumatizing.
Yeah. One, I was just thinking as you were speaking, one practical solution for appropriate adults and police station representatives might be to put onto the custody record that a client suffers from trauma, and even put it into the recording on the interview, so that if down the line an expert gets to see that, you can see it was identified at those early stages. Thanks, Sinead. The next question is to Melissa and Felicity. Can you think of ways that you're able to present evidence of trauma to a decision maker if a client doesn't want it talked about publicly or in front of co-defendants? Melissa, do you want to start with that?
You can put it in writing, and you can lodge it in writing prior to the hearing, and you can refer to, if you're addressing the sheriff, just refer to the document that outlines the history of the client. And if you almost speak in a code, no one's going to understand, apart from the lawyers in the room, about what you're talking about. So I don't think in any circumstances it would be appropriate to bring anyone's previous experiences to an open court that could potentially then be reported to the media, for example. And clients don't want to sit there and listen again to what they've told you, and they don't want to hear it again. They don't need to hear it again. If you tell the sheriff in an appropriate way, they don't need to be re-traumatized by hearing again and again about what's happened to them. So I would write it in, either lodge it in writing, scribble a note down, you know, as you're standing up, or try and speak in code. But I would often say it's not appropriate to discuss this in an open court. However, you know, I've lodged this letter explaining and outlining the circumstances. Quite often in criminal justice social work reports, there's a full background, so we're quite used to saying, if you read page 4, it outlines all of the circumstances. If it's a post-conviction sentencing diet. So I think that's important, because it's all part of the process of not causing any more harm to that person.
That's really helpful. Thank you so much, Melissa. Felicity, any other top tips? Are you on mute?
Yeah, look, I think it's really hard, because in the criminal practice direction, there is a direction about having cases in private, particularly involving vulnerable people. So my view is, not just in the youth court, but in the Crown Court on really serious cases, it should be in private if a child is on trial, but it isn't. There's ample research by Justice that they shouldn't be in the dock, but they are. And I regularly make these applications and often lose, because the issue of that child's vulnerability is not at the forefront of the court's mind, because that's how we do it and that's what the room looks like. So I do think it's problematic, and all I ever say is you've got to be brave enough to raise it, and I do. And that, I'm sure there are lots of lawyers out there will be sitting there and saying, well, so do I, but just remind yourself every time, you know, I've got to stand up and say this should be in private. And when you're dealing with clients that have reports, Melissa's approach is fantastic, but one of the problems is you'll get a prosecutor who will pick out bits and play to the public gallery and pick out something bad from records on a child, and that's what the public gallery hear, and you can bet your life that's what they'll put on Facebook about your client. So I really think there need to be a lot more rules about what is said about this private information, where there are expert assessments as well, how it's used by the parties. And if you're in a multi-handed case, that's all the parties that might want to have a go at your vulnerable clients. So that, I think it comes back to the reason why this publication is so important, because it gives you a foundation as a lawyer to say, well, hang on a minute, here's the research, here's how we should be doing something differently. And if you look at the Equal Treatment Bench book, the criminal practice direction, the youth, it doesn't deal with human trafficking very well, the new youth guidance, and a lot of the guidance around human trafficking that's already available, it is all there. And this publication adds to that to say, okay, look, I know more than you, you've got to do this. And eventually they go sufficiently wrong that we get another case like TS, which is the one about explain to the jury why somebody behaves oddly in court. And eventually we'll have what I call a myths and stereotypes direction, where you say, actually, this is a child, this is what you don't do, in the same way as we have myths and stereotype directions in cases involving sexual offending. And I think the courts are really useful as an area to educate people. I think those myths and stereotypes in cases involving sexual offending is something that I was involved with decades ago. They're just really useful. They're not, judges that don't always get them right, but there's a start. And I think this is a real area where we should be educating the juries and thus educating the public, and judges can say, hang on a minute, you shouldn't be doing that. Don't pick out that bit of the social services record. Don't do that. And unless we're all trained, then that it does take us as lawyers to stand up and say, come on, let's do it differently. Let's listen to Aswini's experience in a different court setting. How do we do this differently?
Yeah, I totally agree. And I think that the idea of reminding ourselves, like, not because we probably normalize it as lawyers when we go to court all the time, but reminding ourselves each time, is this traumatizing the person who's story is I did have one case where a multi-hander where one where I got severed because of the trauma, and another where in mitigation the co-defendants all agreed that I could mitigate in private and they would leave the courtroom. So courts are open to being more creative if you just ask, and you may get turned down, but I think the thing is to keep on asking. Your client is the most important person in the room. And that's what's not understood. The judges think they're the most important. The prosecutors think they're the most important. We often think we are. Actually, you start from your client's the most important person in the room. Even if there's a victim of a crime, they really are once you get to court. And I think that's the very basic. And what we have to do is sort of support ourselves to keep going to eventually get this fundamental reform. We've only got 5 minutes left, but I'd love everyone just to very quickly touch on something. I think a lot of you have touched on this idea of secondary trauma and vicarious trauma, and I think it probably plays into this idea that we don't notice. There is support for lawyers around vicarious and secondary trauma through an organisation called Claiming Space, and I think Lily will put the link on the chat. But could I just go through everybody and just give kind of tips for professionals out there on how to deal with vicarious or secondary trauma? Melissa, shall we start with you?
I always say I'm the worst person to ask because I take it all on board. But I think just make sure in our office we talk about cases. So to my colleagues, we talk all the time. And talking lifts it away from your brain, and it's like a problem shared. So we're always talking, and if there's really difficult things, we'll make sure let's go for a cup of tea outside the office, let's have a chat, and make sure you look after yourself. You need downtime, you need time with your family, you need time with your friends, you need time away from this work, because if you do this work, you obviously want to help people, but it does take its toll on your health. So you've got to look after yourself first and foremost to be able to help other people. But yeah, talking I think is the most important thing, and don't keep it all to yourself. You definitely do feel better, but I think naturally you are going to take a lot of it on board. Thank you, Melissa.
Sinead, a psychologist perspective for all of us secondary traumatized lawyers out there.
Just that as mental health professionals, we all have clinical supervision where you have a space to reflect on all of those things. So, and it's not, I think all of those things Melissa has said is great, but especially when you're working remotely, and especially when your colleagues are carrying a similar caseload, it can be very hard to feel that anybody's got the space to listen to it. So I think anything, I don't know what claiming space is, but anything where you've got somebody outside where you can have, because sometimes you just need a chunk of time to really think about the kind of build up of it, and also what it's tapping into in you, because there's such powerful dynamics. And I just think not just what you're doing, but just I think read the material that you have to go into is I mean most mental health professionals would struggle to cope with what you guys cope with. So it has to be I think there's been loads of really good work, but there has to be a much bigger part of the work, or there'll be a much bigger part of the structures to support people, or there'll be nobody left to do the work. And especially when I think the people doing the work are so committed to it, you're going to go the extra mile all the time. And yeah, so I just think it's amazing what people do, but as Melissa says, it does come at a cost. So some really formal structures need to be in place.
Thank you. Felicity, any tips for you've been doing?
Yeah, I think you have to be self-aware. You have to know when it's all getting a bit much, and that's true for everybody. I think reflective practice is really good. I learned that as an academic, and there's a whole heap of research around reflective practice. So if there's no one available for you to speak to, read up on, in your spare time when you're not too stressed, read up on reflective practice. It's really helpful, and it's a system which I love. And I'll leave you with a quick story, which is this, that there's a therapy dog that's being introduced to the equivalent of the Crown Prosecution Service in Western Australia. So they've recognised the trauma for prosecutors, and they've brought in a therapy dog. And of course, the headlines are, why are we wasting money on a dog? You could pay for another lawyer. But I just thought it was a wonderful change that you get terrifically bad headlines. So I suppose I'm going to leave you on, get a therapy dog in the office to visit. And that's a nice way to
I think that's a great idea. Aswini, any tips from your experience as a practitioner?
Well, I have 2 of my own therapy dogs right here, and they do provide really good therapy. Can I just say, you know, at the self-employed bar, we are very bad at this, at safeguarding ourselves. And so, you know, since I started, I didn't know I could say help. This is really, you know, difficult for me to read these things. And nobody sat with me and said, you know, are you okay? So basically, over the years, I think I've developed a sort of a carapace. You may be able to see it, but it's just that sort of self-protective mechanism that you develop. And some people don't develop it, and you do see that they can suffer. And now, you know, as a more senior practitioner, when I work with junior barristers, I do try very hard to, you know, manage the way the work reaches them, and then talk to them about it afterwards, and not expose them too much to, you know, the levels of that sort of difficult reading that I certainly had. So I think we're very bad at it, and I know that it's now being focused on, which is brilliant. And I know that LAG have just published a book on vicarious trauma, which is also fabulous. So I think now we need to actually put this into practice and start protecting ourselves and our junior barristers and our other barristers. And particularly, I think at the self-employed bar, we have a lot to do in this area. And I don't have any tips apart from read the book and be aware and try and stop yourself from falling into those traps.
Thank you, that's brilliant. And the LAG book was written by Claiming Space, which was the organisation that I referred to earlier. So do get that. And my therapy dog is behind me, fast asleep. Thank you so much to all of our speakers. That was truly amazing. And I can't wait for the day when trauma-informed legal practice in courts is commonplace and everybody is trauma informed in that. But we really appreciate you coming to talk about it to everybody that's here. So that's the end of our session. Thank you so much. The collection of the YJLC legal guides to date can be found on the website resources page. This is number 5 in the series. There are 12 coming, so watch this space for the next one. The next guide will be launched on June the 24th, and it's going to be about the criminal practice directions that Felicity mentioned as they relate to children and young people in the criminal justice system. Thank you so much. We know your time's precious, but really let's all go and make the criminal system a bit more trauma informed. Thank you. Bye, everybody.